I'm sorry.
SJC-12938, Commonwealth v. Dondre, J. Snow.
And we'll hear from Ms. Campbell first.
Thank you, Your Honor. Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. I'd like to acknowledge the trial prosecutor, David McGowan, as well as members of the victim, Maury Scott's family, who are watching this argument virtually. We ask you today to reverse the allowance of the defendant's motion to suppress. Very simply, this is a case about nexus. The motion judge erred because she required too narrow a view of nexus. She ruled, and this can be found on—
I'm sorry, Ms. Campbell, I think Ms. Belger has a problem with the audio.
Hello?
Yes, Ms. Belger, can you hear us now?
Yes, I apologize for that. I don't know what happened. Sorry.
No, that's quite all right. That's to be expected with this technology. We'll continue with Ms. Campbell.
Okay, sorry.
And Ms. Belger, if another problem arises, please do what you did. Tell me, and we'll readjust.
Thanks. Yep.
Ms. Campbell.
Thank you. The motion judge ruled, and this can be found at Commonwealth's Record Appendix, page 69, that the affidavit was faulty in this case because the information was not sufficient to establish that the phone he was using was used to commit the crime. That is an incorrect legal standard. As explained in Hawley, there is no requirement that the search warrant affidavit show that the cell phone itself was an instrumentality of the crime. Moreover, both the motion judge and my sister's reasoning is fatally flawed in that it does not look at the information in the search warrant affidavit in the light most favorable to the Commonwealth, drawing all reasonable inferences therefrom. These inferences can be based on common sense and the practicalities of everyday life. Looking at the facts, the inferences, and the practicalities of everyday life, there was ample probable cause in this case to believe that the defendant was not only implicated in the murder, but that his cell phone would contain evidence of that murder. And that nexus can be found in the fact that minutes after the murder, while the defendant and his co-defendants were engaged in the active cover-up of the murder, the defendant was speaking to the woman who rented him the murder car. Those facts, though not the only facts that establish probable cause, are sufficient standing alone to create and establish probable cause and a nexus to search the defendant's phone for communications. Finally,
more about that. I'm sorry, Ms. Campbell. Can you talk a little bit more about that? Because I'm trying to understand what that shows. What is the inference that we are to draw from the fact that he was talking to his girlfriend and telling her that he was about to be arrested?
Sure. I think it's important the temporal proximity of when that conversation happens to the murder, which is, as the affidavit search warrant establishes, it's minutes after the murder. It's while he's still in the car that was used in the murder, and it's very close in time to when he is seen by a eyewitness appearing as if he's changing his clothes, and when his co-defendant inferably disposes of the murder weapon. That when the police come upon the car, again, which is minutes after the murder, he's on the phone speaking to the person who rented the murder car for him. That is in and of itself evidence related to the crime, because it's evidence as to what he's doing when he's arrested, who he's speaking to when he's arrested, and it's talking to the person who obtained the murder car for him. That in and of itself is a communication that is related to the crime and establishes the necessary nexus. Now, it's important, my sister makes much of the fact that the police later interview the girlfriend the day after and ask her about what the conversation was about. And innocent explanations don't vitiate probable cause in a search warrant affidavit, but it cannot be ignored that first of all, the girlfriend is a self-interested witness when she's speaking to the police, but that the defendant made, upon being brought into custody, many efforts to speak to the police to try to get the car back to the girlfriend. And this is the car that just minutes before was used in a shooting. It has inferably and reasonably evidence of the crime related to it. So for all those reasons, there's a direct nexus between this communication and the murder. Not that there needs to be. If you look at a case like Commonwealth v. Hawley, and especially Commonwealth v. Hawley had two co-defendants, Mr. Hawley and Mr. Pritchett. And Mr. Hawley's probable cause to search his phone, he's on the phone before the murder. It's a drug deal. He's the last person who called the victim. But Mr. Pritchett wasn't on the phone before the murder. What you have to get Mr. Pritchett's text messages in that case is when Mr. Pritchett, minutes after the murder in that case, he's fleeing the scene of the murder. He's at a T station. All we have in that case is a surveillance video where it appears as if he is texting. And this court held that in that case, that appearance of texting so close in time to the murder was enough to get his communications. It was not necessary that the Commonwealth prove that this substance of the communication was actually or certifiably or with any degree of certainty related to the crime. Here we have that it was related to the crime, but it was not necessary for the Commonwealth to make that showing.
Can I ask you about the change of the clothes? There's a dispute in the briefs as to how far that evidence goes, as to whether or not it's one guy putting a sweatshirt on versus people actually bringing clothes to show more of a planned hit.
Sure.
Can you, going through the affidavit, can you tell me what that tells us?
Sure. If you look at it's specifically paragraph 5 of the affidavit, it's a Mr. McDonald who's a named person who calls the police. He stated he could see people moving, and I'm reading from paragraph 5. He could see people moving around in the car, leaving the impression on him that they might be changing their clothes. So it's not just one person, it's movements consistent with changing their clothes. That should be read in relation to a later paragraph, and that's paragraph 15, in which an eyewitness to the shooting itself, when he's shown the co-defendant, he says that it looks like the man who he saw commit the shooting, but he was in different clothes. So it is confirmed that there was clothes changing in the car.
How do you distinguish White, which deals with multiple defendants and a crime does not equal nexus?
Absolutely. There are many ways which White can be distinguished on this fact. The first is you have the defendant using his phone minutes after the murder. You don't have that in White. Even more than that, though, in White, you have a joint venture of, there's 3 individuals, but 2 of them live next door to each other, and the murder is committed. It's a robbery of a convenience store a block away that goes wrong. And so there's nothing to show that they necessarily would have had to use a cell phone to communicate with each other. But even more than that, the facts of the murder itself in White don't implicate electronic communications or the use of any sort of electronic device at all. As I just explained, it's a block away from at least 2 of the co-defendants' homes. They're robbing a clerk, and it's a murder that happens during the course of this robbery. In contrast here, at least we know that the motive for this crime, the co-defendant and the victim were exchanging threatening messages back and forth. So electronic messaging in and of itself is implicated in the very fabric of this murder. More than that, though, you have the car itself, which was specifically rented. The girlfriend tells the police that it was rented to facilitate her move to Fall River. So you have a car that's outside of Boston. It's Fall River, so it's a good location, a good distance away from Boston. You then have the defendant borrowing it, which he would have to facilitate getting the car, going back to Boston, which we know because the car is seen in Boston, it's stopped in Boston, his GPS puts him in Boston, and you have 2 other individuals who end up in the car. And so that suggests that's very different from Onyx White, in which you have none of those sorts of factors.
What about Moran? How do you distinguish Moran?
So distinguished from Moran, in Moran, the distinguishing factor, I think there are 2. The first is the defendant himself in Moran was not implicated in the murder, at least at the time that they tried to get into his cell phone. The second is it doesn't have that same temporal proximity as it does here. The affidavit simply said that they were in communications the day of the murder. It wasn't minutes after the murder, and it wasn't a person who's on his phone talking to the person who rented the murder car. I think those are significant factors that distinguish it from Moran as well. The Commonwealth would also like to point out, I think it's very important to note what this case was argued below. What the defendant raised in his motion to suppress and what he didn't raise in his motion to suppress. If you look at the defendant's motion to suppress, and if you look at the judge's memorandum and decision on this motion to suppress, the defendant solely raised a question of nexus. He said there was no probable cause to believe that there was a nexus for evidence related to this murder to be inside the defendant's cell phone. Yes, Judge Cipher.
Attorney Campbell, I think when we go back and look at all these cases like White, Moran, and when we start with White, some of the ways that the trial courts have interpreted White might have been a little more rigidly than we may have anticipated.
Mm-hmm.
How would you suggest, if we believe that, how would you suggest we frame the language for nexus with regard to cell phones? What is the ideal language concept? Won't be too broad, but won't be too narrow.
Sure. I think the ideal language would recognize that, as the court has in Augustine and Hobbs, in many cases, although they have to do with CSLI, that cell phones are increasingly used in everyday communications. They're increasingly used in everyday life. And that's a practicality of life that cannot be ignored when you're looking at a nexus. That's a factor that absolutely should be considered. But there should be, I believe it really is the traditional probable cause standard, right? That the Commonwealth does not have to prove with any certainty that the items are there. It just has to point to sufficiently credible evidence that the cell phone, based on the facts in the affidavit, the reasonable inferences from the affidavit, and the common sense practicalities of everyday life, that it would contain evidence related to that crime. And certainly communications here in a joint venture murder where it suggests that there is coordination would fall into that category. I disagree with my sister's assertion that there is no factual basis to conclude that there was coordination in this case. As I mentioned before, it's a car that was rented to facilitate a move to Fall River, but as the search warrant affidavit states, and that can be found specifically in paragraph 30, this was a brazen and unprovoked murder. By all eyewitness accounts, the car pulled up, it parked yards in front of where the shooting happened. The front seat passenger jumped out, shot the victim multiple times, and ran back into the car.
Ms. Campbell, on the point of coordination, correct me if I'm wrong, does the affidavit doesn't list or separate out where these folks live?
It does not.
Isn't that a problem? Because if there are three roommates and they're going out to get a burger and all of a sudden they come upon the victim, that's one thing. If we have people who live across the city and they necessarily logically would use their cell phones to come together for that purpose, that's a different thing. And here, a flaw in the affidavit is the failure to list where they live, correct?
It certainly would be better if it listed that, but I don't think it's fatal. I would rely on the Arthur case, in which there wasn't that type of information there, and based on the circumstances of the murder, the court still found and held that there was coordination that would be involved in that type of shooting. I also think that
it'd be much stronger if we had that information, right?
Absolutely, but that doesn't mean that that this inference is not reasonable or not one that you can look in the probable cause calculus as a whole. It's really easy to separate all of these factors out and say this standing alone is insufficient to create probable cause, but that's not how the search warrant should be read, and that's not how the analysis should take place. And when you look at this all and sort of the critical and primary factor is the recency with the phone call in relation to the murder. But I also think it's essential, and I'm anticipating some arguments that my sister will make, that the scope of the search was never raised below, and that there is no challenge to the timing of the search warrant execution.
Right. I'll get to Justice Kaplan in a second, and I think Justice Flake, but let me ask you about the breadth of this.
Yes.
Shouldn't this have been for the time of the shooting? Why do we need like all these cell phone warrants, such a wide breadth? And isn't that a problem in this case?
So my answer to that will be there is no case that talks about having to limit in cell phone searching. There is no case that talks about having to limit the time, and I would caution the court against that because of the way that these searches take place and because it's easy for individuals to conceal timing on their phone. But even if the court were to find that, what you would do is partially suppress the part that was overbroad and partially suppress the part for which there isn't probable cause, and let the part for which there is probable cause stand.
Well, on that point, were there other categories that would have led you to of evidence that would have been found on the cell phone that would be supported by probable cause?
In this case,
Yes.
I think the defendant's location, and the Commonwealth notes this in its brief in its footnote, the GPS that was contained in the phone of the defendant's location at critical times. I believe there's probable cause as to that. Whether or not that was.
If they came to you prior to this search warrant being requested, would you have told them, let's look at a day before and a day after, or hours before and hours after the shooting?
Yes, but just because I would have advised to do something doesn't mean that it's legally insufficient or that it should lead to suppression of the entire search warrant. Do I agree that it could be more limited, that it could be better, that I would have a much easier argument if it was? Absolutely. Do I believe that that means that we should throw the baby out with the bathwater and not hold that there is probable cause for certain categories of evidence in this case, specifically in this case, communications? Absolutely not.
I may have missed somebody, and I apologize, but I think we had questions from Justice Kafka and Justice Link.
You took my breath away. I'm done.
Okay, Justice Link?
Mine too.
Justice Steifer, did you have a question? I thought, oh, Justice Bud has a question.
I just wanted to go back to the question that Justice Seifer asked you about trying to figure out what the rule, how we should express what the rule is. And it sounded like what you were saying would really just would allow almost any cell phone to be searched. If you're saying that, well, we all know that cell phones are used, and all you have to do is show an excess. I mean, that's what we have said, right? Here, if cell phones are used so often, why should we assume that the defendant here was making a phone call that had to do with a crime? And I got that, you know, it's because he's calling the person who rented the vehicle. But I'm not sure. He's also calling his girlfriend and saying, I'm being arrested. So I guess I'm just trying to figure out why that means that his cell phone, you could find evidence of the crime on his cell phone.
Certainly, and I would go back to the Hawley case, in which it shows that the Commonwealth does not have to show that the communication actually is about the crime. I would disagree with you here in that I think the fact that he's using the phone and he's calling the person who rented the car, I think that at trial, that would be evidence that you could admit. And it would be relevant to establish what was going on, the circumstances under which he was arrested, and what he was doing upon being arrested. I don't think it could be discounted that though you could say that's innocent, there is another interpretation in which you could say that it's not innocent, because it has to do with the obtaining of the car that was actually used in the murder.
Well, I understand if it was before the murder, I could get that, but after the murder, and here there's no evidence that, I know it said it in the appeals court opinion that he made the call while fleeing the scene, and I know that that's what happened in Hawley, but I don't see that in the affidavit.
Oh, Your Honor, I disagree with that entirely. It's minutes after the murder. He's in the car. It's while people are getting changed. It's while his co-defendant disposes of the murder, and then the police come upon the scene. It's still minutes after the murder. How this isn't the act of flight and concealment of the crime, I don't know how to say that other than that it's absolutely in there. And I think where you get the flight is that temporal proximity. I think it's actually less in time than if you look at the specific timing and you were to look at the affidavit in Pritchett. Then they were going to a T station that was a number of blocks away. This was 2.2 miles away. They got the call minutes after the murder. The police were right there and they came upon the scene. And so that sort of tight temporal proximity is what I think gets you there. Now, I hear your concerns about the standard that I articulated, but I think where you look at where search warrant affidavits are insufficient and where they are sufficient, it's those connecting specific facts. So it wouldn't be that we have an instance where, we don't have any indication that a defendant even had a cell phone or was using a cell phone or that communications were implicated in the crime at all, right? In that instance, then yes, that would be like Onyx White, in which we were just relying on the existence of cell phones itself and the existence of a joint venture.
Well, Ms. Campbell, we have a nexus standard, and what I believe we do is apply the law, the facts to the law. And
Yes.
Onyx White wasn't sufficient. Here you're arguing this is sufficient.
Correct.
Do you have further
Correct.
questions for Ms. Campbell? I'm tempted to call upon Ms. Belger as Atticus Finch based upon her wonderful icon that she put up, but I'll call on Ms. Belger instead of Atticus Finch.
Thank you. Good morning, Your Honors. May it please the Court. Amy Belger for Dondre Snow. 2.5 years ago, immediately before trial was to commence, the trial court correctly ruled in favor of suppression of evidence illegally seized from my client's cell phone. The trial court correctly found that the search warrant was not supported by probable cause, in that within its four corners, it failed to establish a nexus between Snow's use of his cell phone and the murder committed. The trial court correctly applied Commonwealth versus White in finding that there was no particularized evidence to suggest evidence of the crime under investigation would be found on Snow's phone. The trial court also correctly applied Commonwealth versus Dorelis and did not look beyond the four corners of the search warrant affidavit in reaching its decision. A divided appeals court erroneously reversed the trial court's decision by misapplying Commonwealth versus Hawley and Commonwealth versus Arthur. Those cases are factually distinct from this case. Both of those cases involved search warrant affidavits that contained particularized facts, establishing a nexus between those defendants' phones and the crimes under investigation. Here, as the trial court noted, there is no information in the search warrant to connect Dondre Snow's phone to the victim, to his co-defendant Diggs' dispute with the victim, or to any plan to kill the victim. As established by White, there must be a substantial basis for concluding that a cell phone contains particularized evidence connected or related to the crime under investigation. Only then do police have probable cause to seize and search the device in pursuit of evidence. This is so even where there is probable cause to suspect the defendant of a crime. As the appeals court dissent noted, this court has already acknowledged that the issues at stake here have substantial constitutional significance. In addition, this court has repeatedly recognized that cell phones contain vast amounts of sensitive information about their users. Cell phones are uniquely important, especially now, in light of the ongoing global pandemic and the role they have played in documenting police violence and coordinating protests against that violence. They are deserving of stringent privacy protections. Finally, this court has repeatedly concluded that Article 14's protections against searches and seizures are broader and more restrictive of police power than those of the 14th Amendment. Accordingly, this court should uphold the trial court's decision and by so doing, affirm the White test and the considerations that caused this court to adopt it. Thank you.
Belger?
Yes.
Ms. Belger, can you just respond to Attorney Campbell's argument that because the defendant was calling the person who rented the car, that's just after the murder, that's enough of a nexus right there?
Yes, Your Honor. So my sister described my client's girlfriend as the person who rented the murder car for him. There's no evidence in the record whatsoever to suggest that that is true. He calls his girlfriend when he is getting arrested or he inevitably realizes he's about to be arrested because that car is not in his name. It's rented in the girlfriend's name. That is an expected use of a cell phone of any one of us who would find ourselves in that position at that time. Any citizen who finds himself standing in the shoes of Dondre Snow at the time that he realizes he's going to be arrested is going to call the person whose car is about to be seized in connection with the arrest and let them know what is happening. And in fact, the search warrant affidavit spells this out very clearly and supplies corroboration for what my client told them on the scene was the use of the phone through the girlfriend's interview with police. And when the government offers a search warrant affidavit in court, we accept the contents of the search warrant affidavit as true. And I would suggest that all of those facts militate against a finding of probable cause of any kind that this phone was used in connection with the murder. The evidence that comes before the court is the phone is used in connection with the girlfriend's retrieval of her car because he is about to be arrested. There's no evidence that phone was used in connection with the murder at the time of the shooting, before the shooting, or in flight from the shooting, other than when the police cars come to the scene and it's clear that there's going to be arrest. And for that reason, I would say that there's no nexus in that search warrant connecting his phone to the murder. The only nexus in that search warrant that connects anyone's phone to the murder is the co-defendant Diggs. And if you excise out everything having to do with Diggs, there's nothing left in terms of nexus to Dondre Snow's phone and the crime committed, or to the victim, or to the dispute between the co-defendant and the victim.
Justice Kafka.
So I'm trying to understand, and I don't remember the affidavit right now. Did the affidavit indicate that the girlfriend also had another car? So that not only does she have one car, but she's renting a car in addition to that, right?
She is, because she's moving to Fall River.
Well,
and
that's again, we look at these facts, we can look at the inferences both ways, right? The other inference is that they've rented a car that's not going to be traced to anybody directly. You know, you tend not to drive to murders, you know. So I have trouble with some of your arguments that we can't infer collaboration here. The three of them are in the car. An additional car is rented. He's not calling his mom saying he was arrested. He's calling the person who rented the car that's used in the murder. I don't see this as being like White, where there's just three guys with having cell phones.
If you're saying that this is not like White, it has to be because you're saying that the fact that he used his cell phone at the scene of his arrest is the next.
He used his cell phone to call the person who rented the car. Again, a person who has her own car. Isn't that a suspicious fact? We have a lot of these crimes committed when people rent cars, particularly drug crimes. This is a murder, where they're renting a car that's more difficult to trace back to them. It doesn't seem like it's White to me. This is not just guys, everybody has a cell phone. You pull over three guys, they all have cell phones. White makes that clear that's not enough, although your sister seems to be pushing us a little on that, but this is different.
I don't see this as different, Your Honor, for the following reason. If I'm moving tomorrow and I have my car and a rental car in my driveway, and I'm driving in Boston, and my son jumps out of the passenger seat and goes shoot someone and gets back in, right? And, you know, we get pulled over and I call my husband and say, can you please come get this rental car so we don't get charged for it? I don't see where that's probable cause for the police to take my cell phone and search it. Okay, so when you're looking at probable cause.
Under your hypothetical, you and your son, you rent the car and your son goes out and murders somebody, and then he calls you. I'm wondering why you gave him the car to go off and do a murder. I'm not sure.
Let me ask a different question. On the issue of coordination, isn't it relevant as to whether or not these folks met up beforehand? And you quibble over the change of clothes, but they certainly, three people do a coordinated attack on someone and then are caught minutes later. Who those three people are really the $64,000 question. Your client could say at trial, they picked me up hitchhiking. I wasn't there at the time, but if we look at his cell phone and we see that they planned to meet up, that kind of blows that out of the water. Isn't that evidence of coordination, and isn't that evidence that supports probable cause?
Well, no, Your Honor. We have evidence that there's 3 people in a car, okay? We don't have any evidence that they planned and coordinated to get together to commit a murder. We had evidence that Diggs exited the car and committed a murder. That's all we have. There's no connection to planning or coordinating the murder with phones of those 3. They're in a car.
If you go out to dinner with 2 of your friends, and I see you in a bistro in the back bay, how did you get there? By carrier pigeon?
Well, it doesn't mean that you all arrived in the same car, does it?
No, but the point is, how did you get to that bistro when I see you having dinner? You had to coordinate the trip somehow, and it's by cell phone.
Not necessarily, Your Honor. Is it by cell phone? And, you know, there wouldn't be any reason for the police to be searching in our cell phones to decide how it is we got there at the bistro. We're getting far afield of where we need to be with the analysis of the seizure of Dondre's cell phone at the time that he was being arrested. At the time he was being arrested, he's using the cell phone the way any of us would if we're driving a rental car that needs to be returned by somebody to not incur fees. Right. That's the use of the cell phone at the time, and that is what is said in the warrant as accepted as true by the warrant, the affiant, Detective McLaughlin, as true, that that's what he was using the cell phone for. So he's not saying there's any connection, there's no nexus between any planning and coordination to the murder and the use of his cell phone.
Is it a reasonable inference that the way they get together to do this murder is by use of cell phone? That's the only way they could have planned this, and that's how they end up in the car together.
We can't make up evidence that they got together to plan the murder because there isn't any. The only evidence in the search warrant affidavit and in the record is that 3 people were in a car and 1 got out and shot somebody. There isn't any evidence that there was planning.
We have questions from Justice Seifer, then Justice Kafka, and Justice Budd in order of hands being raised, and then Justice Lincoln. Yes, we'll see how it goes. Justice Seifer.
My question just goes back to some of the language you were using in your argument. First, one was you said there's no connection, there's no evidence of connection of the cell phone to the murder. And later you said it's not necessarily so that they use the cell phones to get to the bistro, perhaps, or to coordinate that. And to me, to say those are 2 ends, they're very extreme on that spectrum. We're not necessarily looking for a connection between the phone and the murder, are we? We're looking for the phone to maybe contain, it's not like he hit the guy over the head with the phone, but that it needs to, we have a probable cause that there's likely to be evidence on the cell phone related to the murder. It's just a probable cause standard, which also goes back to your necessity. So where's the flexibility in the standard as you characterize it?
As long as there's facts that are stated with particularity, White tells us that there's a nexus between the phone and the murder, the White standard says, probable cause is satisfied. What I'm arguing that as to Snow, there are no particularized facts that connect his phone to the murder. The only facts we have are that he called his girlfriend as he was about to be arrested to say, come pick up this rental car. That's it. Any of us who are going to be arrested by the police are going to call somebody. If we're driving a rental car that needs to be dealt with at the time, that is a natural and expected and acceptable use of a phone. That is a generally understood use of a phone at the time. Any citizen who's about to be arrested that has
let me cut you off. You've gone through this before. Let me ask Justice Kafka for his question.
Well, I guess, you know, we're not dealing with suspects who are covering their tracks. We have the shooter sends violent text threats, right? Is that correct? Am I remembering that correctly? The shooter
Yes.
is sent to the victim. They're going to the murder with GPS devices on their legs. He is calling someone right afterwards. Doesn't the fact that we've got a lot of phone activity with this group also suggest that Bhuta's not thinking too clearly. He's threatening and then shooting. He's with this guy. Doesn't that also lend support to the idea that the phone may have communications from Bhuta that are not all that sophisticated? He's not covering his tracks here.
I don't see how that reconciles with cases like, Morin and Arthur, where, you have cases where co-defendants are calling each other, and that's not enough, right? This court has said. So
it's not,
Bhuta
Bhuta is threatening people in text. Bhuta is going to a murder wearing his GPS device. Doesn't that also suggest that Bhuta may be leaving traces on other people's phones, particularly the two other guys he's with when he does the murder?
That is certainly probable cause to search his phone and find that out, right? That Dwayne Diggs, take his phone, okay? You have probable cause to take his phone, and as an investigatory approach, you can see where that leads you. But the fact that Diggs is a bad actor and jumping out of cars and shooting people and escalating things on social media doesn't give you any right to go into Dondre Snow's phone at that point. Take your investigation where it leads you, but where it leads you is probable cause to search Diggs' phone at that point, not Snow's phone.
Justice Bud.
First of all, I think Diggs is Buddha, not Buddha. Anyway, another time. I was looking at the affidavit and just trying to see whether or not there was anything in there about rental cars being used for, for crimes or anything like that. Because I understand that may be, something that you might assume, but I didn't know if it was in the affidavit.
It is not in the affidavit, and I think it's Butter Bear and Slime Butter, depending on who you talk to, which are all these nicknames for Diggs, and the police get that from the victim's phone, calling him Slime Butter as a contact, and from their investigation that's his nickname, right? So that's where the nexus is for Diggs. There's nothing in the search warrant affidavit talking about, rental cars being connected to crimes. Rental cars are more often than not connected to crimes than connected to crimes, I would posit, in our society. And, I also think it gives pause when the appeals court describes my client using his phone to call the girlfriend, whose rental car it is behaving like a nonchalant criminal, that all he wants to do is, communicate information, he's being arrested, please come get your cell phone. It seems to me he's being a responsible person in that situation, to someone accountable for that car. To ascribe criminality to him over what he's done in this case, I think is unfair and inappropriate.
Justice Lake.
Well, I've heard you rely upon White, but White's not the only case in the ballpark here. How about maybe you have distinguished the case that your sister relies upon so heavily that I also wrote, which is the case involving a co-defendant in which we said the texts were admissible.
So I think that's Mr. Pritchard, right, from
Right.
Holly?
That's right.
Yes. So we have Holly and Pritchard, and that's a drug case, and there's a lot of information in that affidavit.
I'm sorry, I couldn't understand what you just said. It was a what case?
A drug transaction.
A drug case. Okay.
So there's a lot of information in the Holly case about the specific use of cell phones in connection with drug transactions. And what you have is you have evidence, you have video surveillance evidence of Hawley using the cell phone right before he goes up to the victim's apartment to do the drug transaction. Then you have the co-defendant Pritchard leaving the scene at the NBA texting. You have the additional information that they don't reside together, and they reside separately and come to the same place. In that situation, I would say those facts are what I would call particularized facts that connect Mr. Pritchard and Mr. Hawley, not just to the arrest, right? So all we have here is connecting Dondre Snow to, I'm being arrested, something needs to be done with this rental car. That is connecting them to the transaction because we have those particularized facts about how in law enforcement's experience drug transactions work with respect to cell phones. And we have no evidence of Mr. Pritchard using his cell phone for anything other than what may be probable cause to believe has something to do with the drug transaction that just ended, where his co-defendant is on the phone before and after. He's texting, and they come, from different locations. We don't have particularized facts like that here. The only facts we have is that when the police were about to arrest Dondre Snow, he called his girlfriend to come get the rental car. That's it. And that's the distinction. And I think that is why this is a straightforward application of White, where you find there are no particularized facts that connect his cell phone to this murder, because the only particularized facts we have are that he engaged in normal activities of any citizen of calling his girlfriend at the time of arrest to come get her rental car. Those are the only facts we have.
Now, I guess I'd like to follow that up with, what is your reaction to your sister's articulation of the proper test that we should be formulating?
I think you should use the White test. The White test is there must be particularized facts in the search warrant affidavit that connect the defendant's cell phone to the crime. And if you apply the test that you already developed to this case, just as the trial court did, this is what the trial court judge did. She took White, she applied it to the facts, she said there's no particularized evidence, this evidence doesn't come in. And of course, I accept the point that certain things weren't briefed below that I brought before the court. I didn't come involved in this until further appellate review, but I looked at it, and when you look at what the Commonwealth was looking to introduce off that cell phone, it's Snapchat videos, it's pictures of my client. They have no temporal relationship whatsoever to anything having to do with this crime. There's no temporal component whatsoever, and it's 80 days after they seize his phone that they even bother to go look for a warrant. And there isn't any case I found anywhere that says 80 days of seizing a person's personal cell phone is anything other than an unconstitutional seizure. So, for that reason, too, it's not just search that we protect.
Was that raised?
It was not raised below, but I cited Va-Meng Zhou in my brief to say a non-appealing party can bring an issue before the court and consider it in your discretion.
I don't think Va-Meng Zhou says that, but you can argue it.
I will argue it then. That is a very important and significant intrusion, right? To seize anyone's personal cell phone, hold it for 80 days.
Well, let me catch up. You're arguing an issue that's not raised on appeal. So, all right. Any further questions to Ms. Bell? All right. Thank you, counsel.
Thank you.